For today's United States Supreme Court case, we look to what is required to form the offense of obstruction of justice. A person is looking to be potentially deported, and they look like they're interfering with a witness. But there's a question as to whether or not there is a proceeding that's actually underway, and whether or not that has to be true in order to form an obstruction of justice. So, what is required for there to be obstruction of justice? Does it require that there be some official court proceeding already underway, or even an official investigation underway? Or is obstruction of justice any time that you interfere with what might eventually fold out to be an investigation or fold out to be a trial? Is it enough to interfere with a witness even before maybe the police are even aware there's a problem, perhaps? So when does obstruction of justice start and where does it end? Let's get started with this. In two immigration proceedings, non-citizens were determined removable. In other words, we're going to deport their asses from the United States on the grounds they had convictions for aggravated felonies of obstruction of justice. On appeal, the Ninth Circuit concluded that the state conviction for dissuading a witness from reporting a crime, hey, witness, please don't tell the police about this. I'd really prefer you not tell the police about this very much, did not constitute an offense relating to obstruction of justice because the state offense did not require that an investigation or proceeding be actually pending. So at this particular point in time, our miscreant over here went to the witness and be like, hey, witness, would you mind, not telling the police about this so very much? I'd really appreciate it if you not tell the police about this crime, possibly with stronger, more threatening language. But the problem is, at the time they said the witness to this, we'd really prefer you not tell the police very much, perhaps with more aggressive language. There was not necessarily any investigation or proceeding actually underway yet because it hadn't occurred yet. So maybe it's really, really early in the crime's behavior. And so the police don't know yet. So we're like, we'd really prefer you not report this, but is it obstruction of justice when there's not actually a investigation or a court case underway? All right, let's find out. By contrast, the Fourth Circuit concluded that a different guy's conviction for accessory after the fact constituted the offense of relating to obstruction of justice, even if the state offense did not require investigation. All right, so we have a circuit split. The Ninth Circuit says it's only obstruction of justice if there is some sort of proceeding actually underway. Maybe it's an investigation, maybe it's a court process, whatever. But it's only obstruction of justice if something is actually already happening. The Fourth Circuit's over here like, that's really dumb. You have told a witness not to cooperate with the police. Maybe it's because the crime literally just happened 5 seconds ago. And you're like, hey, witness, so we'd really prefer you not tell the police about it with more threatening language, perhaps. So that's really, really dumb if that doesn't qualify as obstruction of justice. So we have a difference of opinion. What qualifies as obstruction of justice? Let's find out. An offense may relate to obstruction of justice under a relevant law, even if the offense does not require the investigation be pending. So, yeah, if you tell a witness not to cooperate, even before the police learn about it, yeah, that might be obstruction of justice, yes. Federal law provides that the non-citizens convicted of federal crimes constituting the aggravated felony or removable, otherwise known as deportable, from the United States. Congress expanded the definition of aggravated felony to include offenses relating to obstruction of justice. Dictionary definitions, federal laws, state laws, and the Model Penal Code show that federal or state obstruction offenses relate to obstruction of justice, even if the offense does not require that an investigation be proceeding. So yes, if you tell the witness the crime you literally just saw just happened just now, you didn't see nothing with, threatening gesture or something, that qualifies as obstruction of justice. We're comfortable with that. The extensive body of authority reflects the common sense. Individuals can obstruct the process of justice even where an investigation or proceeding is not pending because the crime just happened just now. So how could an investigation be happening? Because how could the police learn about it? So yes, it's obstruction if you threaten the witness in the immediate aftermath of the crime that they just witnessed just now. Wow. Shocker. Indeed, obstruction of justice is often most effective when it prevents the investigation from proceeding. Yeah, if the witness never tells the cop about it at all, maybe the cop won't investigate it because the cop won't ever know. I witnessed this horrific crime, cop. I'd like you to know about it so that maybe you could look into it. Well, thanks for letting us know so that we can, bring peace to the public order and all. But the witness won't tell him about it, so the cop never knows. Wow. And that's obstruction. Amazing. Deep. Wow. The court declines to adopt an interpretation of the statute that would exclude many common obstruction offenses. Finally, the phrase relating to resolves any doubt about the scope because it ensures the statute covers offense having connection with obstruction of justice, which surely covers common obstruction offenses that can occur when the proceeding is not actually pending at that point because the crime happened literally 10 seconds ago. Yeah, if you suggest, encourage, extol, threaten the witness not to cooperate, potentially could be a problem relating to obstruction of justice, yes. The contrary arguments lack merit. Further, even if a specific prohibition requires an investigation be proceeding, Congress defined offenses under a different section more broadly. So under one section of the law, it does require an investigation to be proceeding. That's all super wonderful. So if you were charged under that statute, yes, it would require an investigation to be proceeding, but not so much this statute. So yes, if you were charged under that other statute, you would be correct. Unfortunately for you, you weren't charged under that statute, so we really don't care. We really don't care what that other statute has. What does that have to do with the price of tea in China? We don't know. Secondly, the historical record does not support the claim that obstruction of justice requires an investigation to be proceeding. Third, reading the covered offenses that do not require a pending investigation or proceeding may require some redundancy, but better overall reading the statute sometimes requires redundancy. So yes, it is true that this statute may overlay the other statute. Sometimes multiple statutes can relate to the same conduct. Wow. Anyone who knows anything about criminal law at all should be well aware that the same conduct might impose multiple different statutes. Wow. This is like deep lore over here that no one knew, right? If you commit a crime, it might be multiple different things at the same time. For example, if you light someone's house on fire, that's arson. If they happen to be in the house at the time, also attempted murder. Also might be burglary because you entered their property with the intent to commit the arson. So you entered their house, you entered their property for the purpose of lighting on a fire. Someone's inside. Wow, it's burglary, it's arson, it's attempted murder, and more. So yes, there's some overlap. We literally don't care. Please don't commit crimes. The fact the government has you 8 different ways is not our problem. Please stop committing crimes. Wow. Fourth, resort to the rule of lenity because we will show you mercy if the law is ambiguous, has no place here because traditional tools of statutory interpretation shows the offense does not require the offense. So yes, we will show you mercy if the statute is unclear because we want things to be clearly illegal. This is very clearly illegal. And it should be clearly illegal without us telling you. This is not one of those things that we should have to tell you is illegal. You should know this is illegal. Should you know, without us telling you, that, telling a witness not to cooperate with a crime, perhaps with some threatening overtures, is illegal. I think you should know that. So we literally don't care. This is not some obscure thing where, occasionally that does happen in the criminal law where it's like no reasonable person could possibly know this is illegal. I think, suggesting, commanding, extolling, threatening the witness not to cooperate is something that the reasonably prudent person should probably know is illegal. So the rule of lenity is of no savior to you. Thus, that brings us to the end of this case of 2 people who are illegal immigrants. And the United States wants to deport them, and they're sad. And in this particular case, the reason we want to deport them is because they did an aggravated felony. Namely, they did offenses relating to obstruction of justice because they might have suggested in some version of the word suggest to some witnesses that perhaps they not cooperate with some investigations, and they're like, that's not fair. The investigation hadn't proceeded yet, so they can't be interfering with an investigation because there is no investigation. The cops have no idea that this happened yet because the crime just happened just now. How can they possibly be interfering with an investigation that hasn't even started yet? And the United States Supreme Court is like, that's really, really dumb. That's incredibly stupid. Yes, you can interfere with an investigation before it ever starts, because here you might be preventing the investigation from starting itself. The obstruction might be in the nature of preventing the investigation from happening because the cops never learn of it. Either way, we don't want people going around and suggesting, extolling, commanding, threatening witnesses not to cooperate, because that sounds really, really stupid. So yes, that's obstruction of justice. Deep. Wow. And that brings us to the end of discussion of this case.